Hello there, my friends. Nancy Cogar and Boomer Time. Thanks for joining me today. I hope you're doing well out there. Hey, guess what? We're at episode 68. 68, can you believe it? How exciting! I am so excited about 68. And I'm looking forward to having you along on the next 68. We're here to stay. Boomer Time is making a big difference. I hear from so many of you telling me that this has made such a major difference in those decisions that you're trying to make when it comes to caring for your older parents or even your own decisions about estate planning. What do I do next? Do I need to do this? You know, sometimes questions just seem like, I wondered about that for a long time, but I don't want to ask it rather, because it just seems dumb, right? Dumb. Well, you might feel that way about, you know, questions you might ask a lawyer. No, I can't ask that. That's just a stupid question. Well, I'm here to tell you, and you've heard it before, there is no such thing as a stupid question. The only dumb question, as you know, is the question that's never asked, right? So today we are going to be talking about dumb questions that aren't so dumb. I could probably learn a thing or two in some of these questions because the circumstances are always different, which makes the questions and the answers different sometimes. And that's why you need an aging advocate like me, right? We'll guide you through that process. So, strap yourself in today. We're going to be talking about dumb questions you were afraid to ask. Number one is, how old do you need to be to make a will? Well, that's a good question. And, I would advise you that it probably the same as being old enough to make a contract, because a will really is a legal document that you're signing, and a contract is essentially the same thing, but for different purposes, right? So if you are under 18, you are not able to make a contract that is enforceable unless there's some other specifications involved. You might need someone else to sign along with you if you're an adult. So I would say, just generally, you have to be at least 18 years old. Now, there's some things you can do. If you're a mega millionaire and you're 15 years old, I'm sure your parents are helping you with your estate planning, but I suspect that that's not most of you out there. If it is and you need help with estate planning, give me a call. I can help with planning for your 15-year-old with mega millions. um, so I think that that's the standard question would be 18. You know, most people over 18, 70% of them don't have anything. So I'm speaking to the masses on the other side of 18. Here's another question. How old do I need to be to receive an inheritance? Well, that is not a dumb question at all. That's a very good question and an important question. Because here's the deal. A lot of times when I meet with people, they'll want to give things to their grandkids, right? Maybe even their great grandkids. Well, guess what? If you are under 18 years old, you cannot legally receive an inheritance. When I say receive, that means have it in your hands and have possession of it. So there's some things that you need to do to make sure that, if you want your minor grandkids or great grandchildren to get something, you need to take some extra steps to make sure that it would be held for their benefit until they become a certain age. And a lot of times you can specify what age. Um, so if you don't do that, you may be looking at the court appointing a guardian, someone outside of your family. That money may rest in the court until that person becomes of age. And that can include a lot of additional cost. I'm sure that's not what you want. Here's another question. And I think this is one that, we may think, but really isn't true. Do I have to be rich to create a will? Well, what's rich, right? I mean, if you have something, Most of us have something. You want to protect that, right? You earned it, you worked for it. So don't you want to have some say in where it's going to go? I would think so. So if you have something and you want to have some direction over where it goes and you don't want the government controlling who's going to get it, then I think you need a will. So, if you're a mega millionaire, you probably get into some more tax planning and all this stuff. But most people have about $500,000 or less. And most often, that's a house, right? That's real estate. You need to do some things to make sure that the way you want it to pass after you're done using it is, memorialized in something enforceable like a will. So that's my answer to that question. So here on the other side, I don't think anybody really wants to ask this question, but it's a good question. So, what happens if you don't have a will? Well, you know, I would say essentially you're forfeiting your right to decide or have a say in who gets what from your estate. I don't think you want to do that. Why would you want to forfeit your rights? That doesn't make sense to me. And it's a simple process. So, what happens if you don't have a will? Well, you're essentially saying that the state in which you live in gets to decide who gets your stuff. With the amount of family difficulties and conflicts that are going on, I have a feeling that most of you out there probably wouldn't want that to happen. Especially if you've got people in your family who spend money like it's going through their hands or have all kinds of problems, and you worked hard for that stuff. So you want to make sure that you're leaving a legacy that matters. So we're going to continue with these so-called dumb questions, and I'm going to take a quick break. And see, they're not that dumb. Stick with me. Welcome back. I'm so glad you're back. And I'm so glad that I'm hearing from more of you. I want to hear what you think of the podcast. Hopefully it's positive, but I do want to hear what you have to say about the podcast. And I want to know what you're thinking, what your questions are. They may make a great episode coming up. So reach out, go to nancycogar.com and send me a line. So I wanted to share a story coming back here. I do get interesting questions from time to time, things that sometimes I'm not expecting. So one recently that I got was a question from a woman. She was an adult, and her mother, her elderly mother, had just passed away. Okay, so her mother passed away, and she left a will. This lady wasn't too happy with what the will said. She thought it was wrong and that she should be getting her mother's things and not her other two sisters. All right. Maybe that's true. I don't know. Um, but her mom made a decision to make her will, and that was what happened. Well, she asked me if she could come in and change her mother's will so that it read the way it should read, that she gets everything and her sisters don't get anything. No, 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 no. You cannot do that. This is your mother's will, not your will. And the testator or the will maker, the intent of the testator is king. So if that's what she wanted, that's what she memorialized, that's what she signed, and that's the last will and testament, then that is what should be submitted to the court. So, no, if you want to take your stuff and give it to somebody specific, then make a will, right? But that was a real question, believe it or not. Here's another one, which More people should probably ask this question, honestly. Where should I keep my will after I sign it? Keep it somewhere where people can find it and access it and they know where it is, okay? Because you would not believe the amount of times I get emails from the Bar Association with people asking, "Do you have a will for so and so? Or does anybody have a will for so and so? Lost will, please help." All the time, people. Okay. So please tell people where they can find your will and make sure that's the original will. That is the one that's needed. Okay. One other point about that, if you put your will in a safe deposit box at the bank, make sure there is someone else on the account. Here's the problem: when you die, the bank is going to freeze that account. They will not let anybody access that safe deposit box. So we can't get your will. And a lot of times when that happens, we have to file something in court saying you don't have a will just so we can get your will. And then we've got to go back to court to bring the will to court and show that you have a will. Unnecessary and creates additional expense, time, right? So don't do that either. But where do you keep your will? Somewhere where people can find it and tell them where it is and make sure it's the original. So, it does take a process to have assets pass. Sometimes it's state law, right? Here's a question: will I get my mom's house when she passes away? Will I get my mom's house when she passes away? Maybe, right? First of all, it's her house. There's a lot of ifs there, okay? If she has a will and she's left it to somebody else, then no. Um, if she doesn't have a will and she doesn't have anybody on the deed, then maybe. If you've got brothers and sisters in that kind of circumstance, then most of you, more often than not, all of you would inherit a piece of the house. So then you got to duke it out with them, maybe pay the value to them, or maybe you're not able to do that. It's not as easy as you think, right? Here's another problem: mom's house, say mom ends up in a nursing home and she gets help with the nursing home cost. Well, more often than not, the house is going to be an issue when it comes to paying back that debt. That is called 10 care recovery here in the state. And it's not that the state's being mean, they actually have a requirement to recover money that is paid out for those benefits. So it's their job. And more often than not, the house is the asset that they go after because most people have a house. So that probably didn't answer your question, right? You wanted to know if mom's house was going to go to you when she passes away, but you can see how complicated this is. So it's not always as obvious as it seems, right? Well, I brought this one up before, but can I change my mom's will? Absolutely not. No, don't do that. You are probably invalidating her will by doing that, first of all. I've seen people write in the corners on this side, put a little scratch through something they decide they don't want in the will. Don't do that. Don't do that. That will create a huge legal problem and may invalidate your will altogether because we don't know, first of all, if you made those changes. When I say you, I mean the person who made the will, or maybe somebody else did it, or maybe you didn't know what you were doing when you did that. We don't know when you did that. So, those are all kinds of questions that come up before a court, and it is not easy to answer those questions. It is also not inexpensive to answer those questions. So, do not do that. First of all, have a will. And this is something, you can go back to my do it yourself disasters. You do not want to make your own will. You can. You can do a handwritten will in the state of Tennessee as long as it's all in your handwriting, dated and signed and identified as your will. But I wouldn't rely on that if you don't have to. And that's because I've seen litigation over that issue. We have to prove that it's the handwriting. We have to prove that it's a will. We have to prove that it was intended to be a will. You're just setting yourself up for disputes, really. So invest in a real will, and I can help you with that, of course, but that's my advice. And see, it's not a stupid question. Let's see. I want to look down at my notes here, but I've already answered a couple of these, but what to do with the original will? I kind of touched on this before, but you leave an estate planner's office and you're going to get, or you should get, the originals. You'll get copies. You may get more copies. What do you do with all that stuff? Well, hopefully you're not going to put it in a envelope or keep it in the envelope it was in and shove it in a drawer. That's not the right thing to do with that. Um, like I said before, it has to be somewhere where we know where to find it, because especially the original will is necessary in order to be probated. The original will, that means the ink signature and the witness's ink signature and the notary that's on it, the original. If you do not have the original, then under the state law here in Tennessee, there is a presumption that you revoked it, that you tore it up, you decided you didn't want it, and that's that. So there is a process to have a copy acknowledged as a will, as the will, but that's a process, right? So anything that's a process under the law costs money and takes time. So I'm just trying to tell you to avoid that. Just make sure you have your original will where it can be found. See, these aren't such stupid questions, and I've got even more, so stick with me and we'll be right back. Welcome back to Boomer Time. It's your host, Nancy Cogar. So glad you're here. We're talking so-called dumb questions that you don't want to ask about estate planning. And you can see dumb questions really aren't that dumb, because common sense is not so common and obvious is not so obvious, right? Here's a question that you may have mulling around in your head, but are reluctant to ask. Do I have to leave my stuff to my family? Well, no. But you have to specify that in an enforceable document. But there's lots of people that you can leave things to other than your family. In fact, I have a lot of people that exclude family members from their estate planning. And you can do that too. I have folks that give to charities. They give to numerous charities. They give to friends. Sometimes friends are closer than family. Uh, Here's one for you. They give to their pets. Yes, pets. I know. Those furry friends, they're so beloved. Why not leave your millions to them? Uh, you know, I laugh, but It happens more than you would realize. I even had a story where a lady left everything to her parakeets. Um, you bet her family was mad, right? You need some specifics if you're gonna leave things to your pets. You can't leave cash to your pets. You have to provide for their care, and so forth. There was a dachshund in New York that one woman left a lot of money to, and her two sons were not too happy about that, and included a budget as far as the dachshund walking around in New York and the time and the exercise that the dog needed, and the clothing and the care and the food. It it worked. So yeah, you got to put some thought into this, okay? Because it's not as simple as you think. And no, you don't have to leave things to your family. But if you don't do anything, uh, that's who it's going to go to. It's going to follow your blood. So anyway, um, another question that I'm asked is, how much do I need in order to put in a will? Well, everybody always thinks the guy next door has more than you do, and that's not necessarily true. Um, in fact, the most common amount in the state of Tennessee is often seen with a small estate. There's actually a law here in the state where you can file a small estate, and that means anything less than $50,000. So, yeah, 50,000 is still a lot of money, but you're not going to find a house around here for $50,000, even cars, right? So that value can add up. So 50,000, that give you an idea. But most full probates are, around 500,000 and less. You got to remember most of Tennessee is pretty rural. Of course, in Chattanooga, there's more wealth than there might be in other areas. Nashville, you probably see some really big estates with the country music folks and landowners and things like that. But yeah, you don't need a certain amount. I would say that you really need just the motivation to decide where you want your stuff to go, right? And have some say in that. There are provisions you can put in place, to control the distribution of your money over time. If you want someone to use it for a specific purpose, you can do that. There's a lot of opportunity. This really is a creative process. I know 70% of people are avoiding doing it, but most people, when they finish with me, they say, wow, you've really made this easy. You've made this really manageable. And to me, that makes me feel like I've done right. And of course we've gotten the work done. So that's a plus plus. I am looking down at my list here, and the next question really is, what happens if I don't find, like, they can't find my documents? Well, if they can't find them, then they're not going to be enforceable. So that goes back to, when I talked about the original. Put it somewhere where it can be found and we know where it is. Um, if you make a will and you take the time to make it and it's valid and we can't find it, then it can't be probated. You need court action in order to put what's in the will into place. That's how that works, right? Well, I think the lesson here is that dumb questions really aren't that dumb. And a lot of times people ask me questions. Well, maybe not a lot of times, but sometimes people ask me questions and I don't immediately know the answer. So there's endless kind of circumstances, but I can find it. That's why we call this a practice. So I want to be involved in that process for you. So if you haven't